California Penal Code Section 466 makes it a crime to have possession of tools that are commonly used in a burglary if your purpose in possessing them is to commit burglaries. So think of it like an electrician or a carpenter. They have a box of tools that they take around with them when they go to a job. And oftentimes a burglar has a box of tools that he or she uses to commit burglary. Well, if you get caught with that box of burglary tools, you can be prosecuted and go to jail, even if the authorities can't prove that you ever committed a particular burglary.
Burglary tools can be any device used to enter into a home, a car, or a dwelling. Some common examples include bolt cutters to enter into a fenced-off area. They can include a crowbar to enter into a building. Anything that is used to unlawfully enter is considered a burglary tool.
Under California Penal Code 466, possession of burglary tools is a misdemeanor. If convicted of possession of burglary tools, you face up to 6 months in county jail and or a fine of $1,000. Furthermore, another consequence of a conviction for possession of burglary tools is the fact that you'll have a criminal record. And having a criminal record can prevent you from obtaining employment or obtaining other benefits.
The crime of burglary tools can be surprisingly difficult for the prosecution to prove. And in fact, a lot of innocent people get wrongfully accused and sometimes wrongfully convicted. The good news is that here at Schaus Law Group, we've had a great record of success in fighting burglary tools charges and helping our clients to get those charges reduced or dismissed.
One defense to possession of burglary tools is establishing that the tools were not being held for the purposes of committing a burglary. People have possession of tools that could be used in a burglary all the time, but if they're being possessed for an innocent purpose, perhaps for their job, perhaps they work as somebody who installs stereos, perhaps they are a handyman, perhaps they have a tool collection. People can possess these things without committing the crime of possession of burglary tools.
Another common defense to California Penal Code 466 is, in fact, the items you were possessing were not tools of a burglary. Now, for example, let's say that you and an accomplice are actually deciding to burglarize a home, and you collect ski masks and sweatshirts and flashlights in your vehicle, and your accomplice has crowbars and pliers to break into the home. Now, say that you're stopped by the police and they find the black sweatshirts and the ski masks and the flashlights. That in and of itself is not enough to convict you under Penal Code 466 because those items in and of itself are not tools or instrumentalities of a burglary. Whereas if they had found you with the crowbars or the pliers and it was readily apparent that you were going to commit a burglary, then you could be convicted.
Another common defense in a Penal Code Section 466 burglary tools case is that the police violated your rights in discovering the items. So maybe the cops detained you on the street and searched your backpack, or pulled you over and searched your trunk, or came into your garage and found what they alleged to be burglary tools. But if they didn't have probable cause to engage in that search, then we can make what's called a suppression motion in court and basically show the judge that the police committed an illegal search and seizure. And if that's the case, then most likely we can get the evidence thrown out of court and the whole case dismissed.